Good morning, peoples. We're going to read this order. We are going to read this order. There's a lot going on with this order. Good morning, everybody. We know the overall results of the order, but I want to read the other bullshit that people are saying. Hmm. We're going to PayPal. Give me a minute, y'all. I'm making a donation. And none of my keyboard, my mouse is all connected to the iPad for some strange reason, and not my. Now, where's the other? What y'all doing up this time of morning? Why are we up this time of morning? Why are we up this time of morning? Idle mind is a devil's playground, they say, right? I'm up early because I can't sleep, and I wanted to read this this order from Judge Mcaffe in regards to Fani Willis. And so I figured I would come on here and read it for everybody. Oh, you had to let the dogs out. This is your normal time. Volleyball tournament. Oh, y'all had stuff to do. So y'all said, let me just go on in here and listen to Tabitha. 18 minutes left of a 12-hour shift. Somebody had to rake the roosters. Okay, all right. So listen, this is the order. It's 23 pages long, and I am going to read it because there's some other stuff in here that Joy Reid brought up in her show last night that I'm like, what? Okay, so we got the overall end result, right? We understand that Fani Willis remains on the case if Nathan Wade resigns from the case, right? Which he did yesterday. It didn't take long. I thought they would at least wait until Monday. But no, they went on ahead and put out the letter, the resignation letter, and Fani Willis put out her letter of acceptance. We might get into that. I gotta go hunt those down. I don't know if I'm going to get into that. The end result is that Fani Willis is staying on the case, right? Now, I also came in later yesterday and talked about this law. Now, all of the MAGA nuts are clinging to this law that Brian Kemp signed into law on Wednesday. And that law is in regards to putting together a commission here in the state of Georgia that will oversee district attorneys in the state. Mm. And if they have an issue with your job performance, your as in a district attorney in the state of Georgia, then they will bring you up on sanctions, right? And those sanctions can equal a fine, can equal a suspension, can equal you being booted out of your prosecutorial role. Remind you, let me remind you that these district attorneys, people like Fani Willis, they are voted into office, right? And typically, if there is a problem with your role, being that you were voted in, it's up to the voters to fire you, which means voters will vote you out unless it's some criminal actions going on. I believe the governor can then step in and boot you out and hold a special election, right? So they created this commission when they didn't create the commission yet. Let me back up. They want to create this commission, so they introduced legislation to be able to put this commission together. And this commission was going to fall under the state Supreme Court, meaning this commission is not allowed to run rogue. They, in turn, answer to the state Supreme Court. And so last year when they introduced this legislation, it went to the state Supreme Court. The state Supreme Court refused to sign off on it because it goes against the state constitution. Okay? They were like, no, this language goes directly against what the state constitution says, right? Furthermore, you are circumventing the will of the people. So it just sat there. It sat there because the state Supreme Court would not sign off on it. So what they did, the racist Republicans in this state, what they did was they rewrote the legislation and cut out the state Supreme Court altogether. Okay? Leaving them the all ruling authority over district attorneys in this state. So if this commission, if anybody brings information to this commission against a district attorney, and this commission agrees with the information that's brought forth, they can sanction that district attorney, they can boot out that district attorney, circumventing the will of the voter. So who do you think they made this legislation to try to get rid of? That would be District Attorney Fani Willis. That would be District Attorney Fani Willis. Now they will tell you, "Oh no, this wasn't brought forth just to get rid of District Attorney Fani Willis." If you believe that, Y'all know what I say. I got some magic beans to sell you. So, with all of that explained, district attorneys in the state are rising up to challenge the legislation. They're challenging the legislation. So it's not a slam dunk yet, even though Brian Kemp has signed it into law, it's being challenged. I don't know if it's enforceable, if this commission is enforceable. First of all, they have to find people to sit on the commission. Once they do that, I don't know if it's enforceable, being that it's being challenged. Now, let me remind you, Brian Kemp is Killer Mike's boy. That's Killer Mike's boy. Mm-hmm. Killer Mike stomped against Stacey Abrams in favor of Brian Kemp. Brian Kemp, who actively has signed into law to suppress the black vote. Mm-hmm. Brian Kemp, who actively does nothing for small black-owned businesses here in the state of Georgia. But I'm sure Killer Mike's black-owned business is doing well. For everybody else, I'm sure theirs is not doing as well as Killer Mike's. Remember that. Killer Mike, who is going around the state to amp up black men to vote against Joe Biden. It worked with Stacey Abrams. We'll see if it works for Joe Biden. Killer Mike, who is stomping against Joe Biden and for RFK Jr. Stacey Abrams is what we needed. She has so many plans for this state that was going to be wholly beneficial for black people in this state. And Killer Mike went with the white supremacist. There's no other way to say it. Killer Mike supported the white supremacist. Killer Mike is still supporting white supremacy. So, now the person that Killer Mike supported has written into law to get rid of district attorneys by way of this special commission, and they will be gunning for Fani Willis. On top of that, even though currently, oh, this is what I need right here, but I need somebody. On top of that, the next step for these MAGA nut jobs, the next step is going to be for them to go to, the ethics board. They already tried to go to the ethics board of Fulton County. Ethics board of Fulton County say, y'all don't know what the hell y'all doing. Fani Willis was appointed basically by voters through the state. You have to go through the state. So they trashed the request to go before the ethics board of Fulton County. They now need to go before the state. So that will happen. But there's other stuff in Judge Mcafee's order. Let's get into it because Judge Mcafee is up for re-election, as I believe Fani Willis is. Fani Willis is doing her job. I believe she will win re-election. Judge Mcafee, if what's in this order true, he might have turned off a whole bunch of black voters here in the state. Okay. So, the state of Georgia versus all of these people. These are the people who brought forth this craziness that resulted in the hearing with Fani Willis. And that would be Donald Trump, Rudy Giuliani, Mark Meadows, Jeff Clark, Robert Cheeley, Michael Roman, David Shafter, Harrison Floyd, the black man, Harrison Floyd, and Kathleen Latham. All of these people are being charged through Fani Willis's RICO case. They are the co-defendants to Donald Trump in Fani Willis's RICO case against them. Okay? So, let's get into it. On January 8th, 2024, Defendant Roman filed a motion to dismiss the indictment and disqualify the Fulton County District Attorney's Office. 8 co-defendants later joined and supplemented the motion, raising additional grounds for disqualification. Among other allegations of disqualifying conduct, the defendants contend that the district attorney obtained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney Nathan Wade, whom she personally hired to lead the state's prosecution team. More specifically, Defendant Roman alleges that the district attorney and state assistant district attorney Wade traveled together on multiple vacations with Wade, covering many of the associated expenses. Now, let me remind you, what came out of the hearing was the total cost of what they couldn't prove but possibly was about $3,000 that she could have benefited from. About $3,000. And that's not coming from the court itself. That's coming from commentators that I've seen out on social media and on MSNBC. $3,000. The state responded with an affidavit arguing that the district attorney had not received any financial benefit through her relationship with Wade, and that their personal travel expenses were roughly divided equally. As alleged, the claims presented a possible financial conflict of interest for the district attorney. More importantly, the defense motions and the state's response crafted a conflict in the evidence that could only be resolved through an evidentiary hearing, and one that could not simply be ignored without endangering a criminally accused constitutional right to procedural due process. After receiving 2.5 days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster, the court finds that defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. Now, to me, that's where it should have ended. Why is there 20 other pages attached to this? I don't know. That's where it should have ended. If the judge found, because that was the whole premise of this, right? If the judge found that they didn't meet the burden of proof, that's it. That's all. Nothing else should have been said. But we got 21 other pages to go through. He had something to say, okay? The other alleged grounds for disqualification, including forensic misconduct, are also denied. Okay, well, it could have ended there, but it didn't. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, an appearance that must be removed through the state's selection of one of two options. The defendant's motions are therefore granted in part. Now, this is to appease the MAGA nuts. because the MAGA nuts feel that what has happened is improper. He's now appeasing the MAGA nuts. Because y'all feel that this relationship was improper, this is what I'm going to order. Okay? Actual conflict of interest. Our highest courts consistently remind us that prosecutors are held to a unique and exacting professional standard in light of their public responsibility. Their responsibility and their power. Every newly minted prosecutor should be instilled with the notion that she seeks justice over convictions and that she may strike hard blows but never foul ones. Most importantly, prosecutors are expected to assume a role beyond a mere advocate for one side and must make decisions in the public's interest, not their own personal or political interests. Recognizing these are not empty slogans nor toothless admonitions without practical effort, Georgia courts have not hesitated to step in and use their inherent authority to disqualify a state prosecutor when required, especially when that prosecutor labors under an actual conflict of interest. Disqualification of a prosecutor due to a conflict of interest is thus not a creature of statute so much as it is a judicial remedy recognized by our appellate courts since their formation generally on grounds of public policy as the administration of the law should be free from all temptation and suspicion so far as human agency is capable of accomplishing that object. The Georgia Supreme Court has most recently denoted conflicts of interest and forensic misconduct as the two generally recognized grounds for disqualification. A conflict of interest includes acquiring a personal interest or stake in the defendant's conviction. In such circumstances, no showing of prejudice by a defendant is required. This is so because the prosecutor's duty to the public creates an additional public interest that must remain unconflicted in every criminal case. A determination of whether a prosecutor is laboring under a conflict of interest is a fact-driven one. In this case, Special Assistant District Attorney Wade's manner of payment is not actionable on its own. Whenever a private attorney like Wade is paid by a billable hour, a motive exists to extend or prolong the assignment. This, however, is a tension that the legal profession has long accepted. It is also the type of speculative status violation that our courts have regularly denied as insufficient grounds for disqualification absent solid proof of some other conduct. Thus, Wade's oath of office, in combination with the supervision theoretically provided by a neutral and detached district attorney, should generally be sufficient to dispel the appearance of that improper incentive. Nor would a romantic relationship between prosecutors standing alone typically implicate disqualification, assuming neither prosecutor had the ability to pay the other as long as the relationship persisted. But in combination, as is alleged here by the defendants, a prima facie argument arises of financial enrichment and improper motivations, which inevitably and unsurprisingly invites a motion such as this. As to the financial allegation, The court makes the following factual findings. On November 1st, 2021, the district attorney, that would be Fani Willis, hired Nathan Wade to serve as special assistant district attorney and lead the investigation that produced the indictment in this case. The district attorney considered at least one other option before hiring Wade. That's correct. Fani Willis went for a former governor first. She wanted him to try this case, but he refused because he didn't want to have to deal with the MAGA nuts threatening him, and he didn't want to have to deal with all of the work that was going to go into it. But most importantly, he didn't want to deal with being threatened. Okay? So Fani Willis did attempt to hire someone else. They declined, which led to Fani Willis extending an offer to he's talking about extending an offer to former Governor Roy Barnes, who declined. The contract allowed a $250 hourly rate, a relatively low amount by Metro Atlanta standards for an attorney with Wade's years of service, and contained a ceiling on the maximum number of hours permitted. So, Fani Willis and Nathan Wade agreed to a $250 hourly rate, which is far below what other attorneys make here in the state. Okay? Under the terms of the first contract, the first contract I'm guessing is Roy Barnes. Oh wait, under the terms, let me read. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicates that Wade ever received permission to exceed those monthly hour caps. His contract was renewed on November 15, 2022, and again on June 12, 2023. Between October 2022 and May 2023, the district attorney, Fani Willis, and Wade traveled together on 4 occasions that resulted in documentable expenses. So he's saying between October 22nd and May 2023 that when they traveled together, they had documented expenses. The first included an extended trip in October 2022 to Miami and Aruba and a cruise. Wade initially covered expenses for the October 2022 trip, totaling approximately $5,223. In December of 2022, the two flew to Miami for another cruise, for which the district attorney paid $1,394 for plane tickets, while Wade purchased passage for the cruise, along with other vacation-related expenses totaling approximately $3,684. In March of 2023, the two traveled to Belize, where Wade covered resort and restaurant expenses in the amount of $3,000. In May of 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides in the amount of around $2,829. In addition, the two described taking a number of day-long trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. They also admitted to dining out on multiple occasions and taking turns covering the bill. With seemingly full access to Wade's primary credit card statements, the defendants did not produce evidence of any further documentable expenses or gifts, nor were any revealed through the testimony. In total, defendants point to an aggregate documented benefit of at most approximately $12,000 to $15,000 in the district attorney's favor. The district attorney and Wade testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Both testified that the district attorney regularly reimbursed Wade in cash and if not reimbursed, the district attorney covered a comparable, relatable expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000, and that she gave him money for both cruises. She further claimed that she reimbursed Wade for the entirety of the Belize trip and that she paid for the Napa Valley excursions. Finally, while Wade could have bought meals in 2020, which totaled more than $100, she would also regularly pay for his meals. Such a reimbursement practice may be unusual, and the lack of any documentary corroboration understandably concerning. Yet the testimony withstood direct contradiction, was corroborated by other evidence. For example, her payment of airfare for two on the Miami trip, and was not so incredible as to be inherently unbelievable. However, as the district attorney herself acknowledged, no ledger exists other than a best guesstimate. There is no way to be certain that expenses were split completely evenly, and the district attorney may well have received a net benefit of several $100s. Despite this, after considering all the surrounding circumstances, the court finds that the evidence did not establish the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was or currently remains greatly and pecuniarily interested in this prosecution. So he's basically saying they had the burden of proof to prove that she got some huge financial gain as a result of hiring Nathan Wade. They couldn't prove that. So, yeah. In addition, and much more important, the court finds, based largely on the district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute this case. While, hold on, while a general motive for more income can never be disregarded entirely, I get what Joy is saying. It's these little things that he adds onto what he's saying, where it could have just been shut off, right? And the little things that he adds on to it gives fervor to the MAGA nuts. He could have left it there, right? Was not a motivating factor on the part of the district attorney to indict and prosecute this case. He could have left it there, but no. He had to throw the MAGA nuts a bone. While a general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or any great need. Yeah, she was making over $200,000 a year. She wasn't broke, right? That doesn't even include whatever she was doing on the side. I don't even know if she could do side work as a district attorney, but nevertheless, she wasn't broke. She was making, even though she's voted in this position, she is a paid person, right? So she's making over $200,000 a year. That's a whole heck of a lot of money here in the state of Georgia, okay, per year, without any indication of excessive expenses or debts. And mind you, remember, she's probably living on the state's dime at this point, because she can't even live in her house where she pays the mortgage. She can't live in that house because of the MAGA nuts. So wherever she is, it's probably being paid for by the state. We're probably paying for that, and I have no problems with it, because she has to be safe. They're paying for wherever she's living, and they're paying for her top-notch security, right? So she's making money, but yet we're paying for her living expenses because she's being threatened regularly. Okay. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. Now, that's a fact. While prejudice, he can't never just stop. Just stop, right? While prejudice is not a required element for disqualification, it is relevant to considerations of due process and the defendant's requested remedy of complete dismissal. Defendants argue that the financial arrangement created an incentive to prolong the case. But in fact, there is no indication the district attorney is interested in delaying anything. No, she ready to go to trial. Remember, she said that. Somebody, one of those defendants tried to call her bluff and wanted, their trial, their case to go forward real quickly because they were trying to bet on the fact that she wasn't ready. And she was like, okay, well, let's go then. It was Donald Trump who then came back and said, no, we need to delay this case. Where am I? Indeed, the record is quite to the contrary. Before the relationship came to light, the state requested that the trial begin less than 6 months after indictment. Soon thereafter, the state opposed severance of the objecting defendants who did not demand their statutory right to a speedy trial. The state argued that it only wanted to try the case once. Remember, she said she was going to try everybody together. I was like, girl, I don't know how you're going to do that. But okay, I'm going to roll with you, Fani. All 18 of them in the courtroom at one time, it's going to be a fucking circus. That was my thought. But Fani was like, I'm with it. Let's go. She was ready. She was like, I'm with it. Let's go. And then that's when Donald Trump, let me keep going. The state amended its proposed timeline in November 2023 to request that the trial commence less than 1 year after return of the indictment. And even before indictment, the district attorney approved a grand jury presentment that include fewer defendants that the special purpose grand jury recommended. By extending the duration of this prosecution or engaging in excessive litigation, without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on the case, the defendant's claims of an actual conflict must be denied. This finding is by no means an indication that the court, he can't just stop there. He just can't stop there, y'all. He got to throw the MAGA nuts a bone. The finding is by no means any indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony. So now he's admonishing her for how she behaved while testifying during the evidentiary hearing. He's admonishing her for going in there and telling that merchant lady, this is a lie. You are a liar. He's admonishing her for standing 10 toes down and telling these people that she is not the one on trial. No matter how hard you try to put me on trial, it's these people that are on trial. They are the ones who broke the law. So he's admonishing this grown black woman like she's a child. Okay. Wait, where am I? This tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. These people are trying to mess with this woman's credibility. These people have brought these allegations, which in turn brings her personal private business into a courtroom for the world to see. And he's saying to her, your behavior was just unprofessional, because she is defending herself. Furthermore, from all of the legal minds that I've seen, he shouldn't even have allowed this shit to occur. This hearing, rather, it is the undersigned's opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices. Got to throw those MAGA nuts a bone. Even repeatedly. And it is the trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. Other forms or sources of authority, such as the General Assembly. I know this motherfucker isn't. If this man shows up on my ballot, I, I won't be voting for him. Yeah, I won't be voting for his ass. So not only is he throwing the MAGA nuts a bone, he's telling them where they can go. Even though he's allowing her to stay on the case, he's telling these people where they can go to file more complaints against Fani Willis. Okay? Okay? Hold on. Let me take another sip. Y'all just dragged this woman. He just dragged this woman into this hearing and allowed these people to bring forth bullcocky, to taint her character, to paint her as some hoe in the streets, to paint her as someone who doesn't pay her bills, because remember, they brought up some type of lien. Some lien she had some years ago, child. He allowed them to bring this shit to the forefront, knowing, he knows that the evidence they had, he knew it from jump. The evidence that they had wasn't going to be able to prove that she did anything wrong, because he knows Georgia law. Now he's telling them where they can go, since he can't remove her from the case. Now he's telling them where they can go to further attack Fani Williams. Okay, here we go. And it is the trial court's duty to confine itself to the relevant issues and applicable law properly before it. Other forms or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County, may offer feedback on any unanswered questions that linger. But those are not the issues determinative to the defendant's motion alleging an actual conflict. Listen, I'm not taking her off the case, but yeah, I will have her remove Nathan Wade off the case to appease you MAGA nuts, because I want to get y'all's votes, because I'm up for re-election, and because I have to let her stay on the case, because she really hasn't violated any laws. These people have proven no conflict. They have not proven that she financially benefit from anything. Furthermore, y'all got people that's married to each other. Y'all got people that are dating each other. Even though all of that is going on, here's where you can go. Here's where you can go to try to get her taken down. Baby, if this man shows up on my ballot, Judge McAfee, if you show up on my ballot, I won't be voting for your ass. I won't be voting for your ass. Whoever your Democratic challenger is, that's who I will be voting for. Appearance, we're getting into a section titled Appearance of Impropriety. Right, Coach Long. There's no law, there's no statute that says she can't be in a relationship with a coworker. None whatsoever. Y'all keep mentioning Clarence Thomas. Child, they don't give a shit about Clarence Thomas. Clarence Thomas has gotten millions of dollars in vacations, in gifts. His wife has gotten millions of dollars. His wife participated in the insurrection, and none of these MAGA nuts have anything to say about Clarence Thomas. Not one of them has brought Clarence Thomas to the forefront to sit in a hearing. Not one of them has filed suit against Clarence Thomas. They don't even speak Clarence Thomas's name when it comes to impropriety or financially benefiting from that position. That's why you can't take MAGA nuts seriously. Okay, so we're heading into this section, appearance of impropriety. Finding insufficient evidence of an actual conflict of interest does not end the inquiry. Our appellate courts have endorsed the application of an appearance of impropriety standard to state prosecutors, even without any explicit finding of an actual conflict. Hold on. I guess I got to read all of this. Standard to prosecutors, even without any explicit finding of an actual conflict. Finding insufficient evidence of an actual conflict of interest does not end the inquiry. Our appellate courts, so he's telling them they can appeal this. They can take this higher. Our appellate courts have endorsed the application of an appearance of impropriety standard to state prosecutors, even without any explicit finding of an actual conflict. Yeah, okay, so we can delay this even further if you want to appeal this. And then it goes to mention all of these other cases. See Battle versus State 301 Georgia 694. Certainly a conflict of interest or the appearance of impropriety from a close personal relationship with the victim may be grounds for disqualification of a prosecutor. Is she in a relationship with any? Is she in a relationship with anybody other than her? Well, she's not even in a relationship with him anymore. She broke up with him, but she was in a relationship with her special assistant district attorney. That relationship is no more. So why are we including this in this? Why are we saying that based on this case from a close personal relationship with the victim? Who's the victim that she could possibly be in a relationship with? What? I'm confused. And he's saying this may be grounds for disqualification of a prosecutor. Who's the victim that she's in a relationship with? Who's the victim that she's in a relationship with? I'm not an attorney. I have a bachelor's in business. I'm not an attorney, but who's the victim? I know we're not looking at Donald Trump as the victim, and she's not in a relationship with Donald Trump. Emphasis added, Greater Georgia Amusement LLC versus State 317 Georgia App 118, 122, physical precedence only, a district attorney may not be compensated by means of a fee arrangement which guarantees at least the appearance of a conflict of interest. Later deemed persuasive by amusement sales, a prosecutor's close personal relationship with the victim in a case may create at least the appearance of prosecution unfairly. Who's the victim? That she could possibly, are they saying Nathan Wade is the victim? What? I'm confused as to why this was added. Based on private interest rather than one properly based on vindication of public interest. In that case, the individual prosecutor who has the conflict may be disqualified. Davenport versus State, granting new trial after concluding that under such circumstances there is at least the appearance of impropriety. Child, I don't even know why this was. I don't even know why this was added. I'm moving on. Oh, and there's more. Okay. Labeling appearance related argument irrelevant to the lack of actual conflict. The cases cited here that resulted in disqualification did not hold that actual conflict is a necessary prerequisite. The state nevertheless argues that the facts presented suggested as much. And while that may be so in some instances, the opinions do not make that finding, and this court cannot ignore the explicit language of the Georgia Supreme Court and multiple opinions from the Georgia Court of Appeals. Further, while Davenport is the first instance this case can find where the exact phrase appearance of impropriety is used to assess the disqualification of a state prosecutor, the reference to Caesar's wife in Nicholas versus State in the against all temptation and suspension demonstrate the principle has long been endorsed in Georgia law. While formally undefined in Georgia precedent, an appearance of impropriety is generally considered conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. Black Laws Dictionary 122-23, Judicial Recusal Standards, a reasonable person is not an uninformed member of the public with only a passing knowledge of facts at hand. See Cheney versus United States, This must be the standard, as otherwise, in this case, a casual, uninformed, or misinformed observer might believe the district attorney must recuse herself merely because her father shares a last name with a co-defendant. Nor is a reasonable person hypersensitive or unduly suspicious without an understanding of the relevant legal standards and judicial practice. The appearance standard recognizes that even when no actual conflict exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. Thus, it is that sometimes an attorney, guiltless in any actual sense, nevertheless is required to stand aside for the sake of public confidence in the probity of the administration of justice. This court finds that it can and indeed must consider the appearance of impropriety as a basis for a state prosecutor's disqualification, especially in recognition of the critical role that the prosecutor plays in the criminal justice system. One final observation can be gleaned from a careful study of our appellate decisions applying this standard. The remedy can vary. Unlike an actual conflict, the finding of an appearance of impropriety does not automatically demand disqualification. Our Supreme Court has previously analyzed disqualification under an appearance standard in a civil case using a continuum, recognizing that disqualification is not always the appropriate outcome. So I didn't watch the hearing altogether. So I'm guessing at some point during the hearing they were saying that the appearance of impropriety could lead to disqualification, and he's saying not necessarily. That's what I'm picking up from it so far. At one end of the scale, where disqualification is always justified and indeed mandated, even when balanced against the client's right to an attorney of choice, is the appearance of impropriety coupled with a conflict of interest or jeopardy to a client's confidences. In these instances, it is clear that the disqualification is necessary for the protection of the client. Somewhere in the middle of the continuum, I feel like I'm saying that word wrong, is the appearance of impropriety based on conduct on the part of the attorney. As discussed above, this generally has been found insufficient to outweigh the client's interest in counsel of choice. This is probably so because, absent danger to the client, the nebulous interest of the public at large in the propriety of the bar is not weighty enough to justify disqualification. Finally, at the opposite end of the continuum is the appearance of impropriety based not on conduct but on status alone. This is insufficient grounds for disqualification. The Supreme Court further noted that disqualification due to an appearance of impropriety should rarely occur. Okay, so what I'm gathering is that one of them attorneys must have said that she could be disqualified simply based on the appearance of impropriety. And he's saying that's not necessarily the case. The Supreme Court further noted that disqualification due to an appearance of impropriety should rarely occur when there is no danger that the actual trial of the case will be tainted. Similarly, in Billings versus State of Georgia, although the Court of Appeals found the existence of an appearance of impropriety, it noted that the appearance could be cured through screening the affected prosecutor from participation or discussion of the affected case. So, based on this, I'm guessing is how he came to the order of removing Nathan Wade. That's what I'm picking up. Hold on, where was I? Appearance of it noted that the appearance could be cured through screening the affected prosecutor from participation or discussion of the affected case. These cases indicate that a trial court can consider alternative solutions to cure the appearance of impropriety. Nor would the finding of an appearance of impropriety on the part of District Attorney herself, in contrast to an actual conflict, necessarily result in the disqualification of the entire Fulton County District Attorney's Office. Hold on, y'all. I gotta re-verify. I don't know when they started making us do that. Yeah, Jojo, the judges, I believe he's citing these particular cases to validate why he came to the conclusion to say, okay, Fani, you can stay if you get rid of Nathan Wade. Mm, where was I? Hold on. Nor would the finding of an appearance of impropriety on the part of the district attorney herself, in contrast to any to actual conflict, necessarily result in the disqualification of the entire Fulton County District Attorney's office. Because if she goes, the whole office goes, which means a whole different office would then have to take this up. A whole different office who knows nothing really about the case, which would further delay the case. If you can find another attorney's office to take the case. Okay, where am I? The district attorney in McLaughlin was absolutely disqualified due to a personal interest in the prosecution. As a result, assistant district attorneys appointed by the district attorney lacked any authority to proceed. McLaughlin did not address an appearance standard and made a point to limit the total disqualification to instances of absolute disqualification. When the appearance of a conflict exists, only the affected prosecutor, be they elected or appointed, is affected. The individual prosecutor who has the conflict based on at least the appearance of impropriety may be disqualified from participation in the case, but not all other prosecutors who work with him. Distinguishing Davenport, an appearance of impropriety case by noting that the district attorney's disqualification did not require disqualification of an entire office. With these principles in mind, the court finds that the record made an evidentiary hearing established that the district attorney's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct and impacts more than a mere nebulous public interest because it concerns a public prosecutor. Even if the romantic relationship began after Wade's initial contract in November 2021, the district attorney chose to continue supervising and paying Wade while maintaining such a relationship. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. This lack of a confirmed financial split creates the possibility and appearance that the district attorney benefited, albeit not materially, from a contract whose award lay solely within her purview and policing. Most importantly, were the case allowed to proceed unchanged, concerns raised by the defendants would persist. The MAGA nuts. It would persist. It's going to persist anyway. As the district attorney testified, her relationship with Wade has only cemented after these motions and is stronger than ever. Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with district attorney. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have, um, he says, as the case moves forward, reasonable members of the public. How many of y'all believe the MAGA nuts are reasonable? I don't believe they're reasonable. Judge Mcaffe is playing in my fucking face. As the case moves forward, reasonable members of the public could easily be left to wonder whether financial exchanges have continued, resulting in some form of benefit to the district attorney. Mm-mm. Or even whether the romantic relationship has resumed. Put differently, an outsider could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. Judge Mcaffe, I very well could think that you are not exercising your independent professional judgment totally free of any compromising influences. Mm-hmm. That's what I think about you, Judge Mcaffe. Mm-hmm. As long as Wade remains on the case, this unnecessary perception will persist. So yeah, this is all of this was to justify his reasoning for removing Nathan Wade from the case. And this is based on reasonable people. No, this judgment is not for reasonable people. This judgment is for the MAGA nuts. The testimony introduced, including that of the district attorney and Wade, did not put these concerns to rest. During argument, the defendants' focus largely pivoted from the financial concerns to disproving the testimony of the district attorney, namely that her romantic relationship actually predated the November 2021 hiring of Wade. On that front, the court makes a few brief observations. First, the court finds itself unable to place any stock in the testimony of Terrence Bradley. That's the black man, the other attorney that was, yeah. His inconsistencies, demeanor, and generally non-responsive answers left far too brittle a foundation upon which to build any conclusions. While prior inconsistent statements can be considered as substantive evidence under Georgia law, Bradley's impeachment by text message did not establish the basis for which he claimed such sweeping knowledge of Wade's personal affairs. In addition, while the testimony of Robin Yearty, I think she's the hey Charlena, I think she's the former employee of the DA's office that got fired, raised doubts about the state's assertions. It ultimately lacked context and detail, even after considering the proffered cell phone testimony from defendant Trump, along with the entirety of the other evidence. Neither side was able to conclusively establish by a preponderance of the evidence when the relationship evolved into a romantic one. However, an odor of mendacity remains. So he's saying this whole thing, this relationship, even though they couldn't, with this appearance of impropriety, but they couldn't really prove that Fani Willis benefited financially from her relationship with Nathan Wade. He's saying this stinks. I think it stinks, Judge Mcaffe, that you allowed this circus to take place in your courtroom. I think it stinks that you're sitting on a bench judging your coworker. I think it stinks that you are bending to the will of not reasonable people while talking about that you're dealing with reasonable people. I think it stinks that you give these MAGA nuts, including Donald Trump, more bones to chew on to attack a black woman. Mm. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court. Such an expectation would mean an end to the efficient disposition of criminal and civil proceedings. Yet reasonable questions about whether the district attorney and her hand-selected special assistant district attorney, Nathan Wade, testified untruthfully about the timing of their relationship further underpin the finding of an appearance of impropriety and the need to make proportional efforts to cure it. Untimely dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud of impropriety and potential untruthfulness found here. Olson versus State, dismissal of an indictment is an extreme sanction used only sparingly as a remedy for unlawful government conduct. She didn't break no laws. She didn't break no laws. Nathan Wade didn't break any laws. There has not been a showing that the defendant's due process rights have been violated or that the issues involved prejudice the defendants in any way, nor is disqualification of a constitutional officer necessary when a less drastic and sufficiently remedial option is available. The court therefore concludes that the prosecution of this case cannot proceed until the state selects one of the two options. The district attorney may
from Beautiful's MacBook Pro.
The district attorney may choose to step aside along with the whole of her office and refer the prosecution to the prosecuting attorney's counsel for reassignment, or Nathan Wade can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence, distracting from and potentially compromising the merits of this case. Forensic misconduct. Can't end there. Forensic misconduct. We got to throw more bones to the MAGA nuts. The Georgia Supreme Court also recognizes forensic misconduct or improper comment by the state as grounds for disqualification. So he's letting Donald Trump and them know that they can now take this up to the Georgia Supreme Court. One example of such forensic misconduct is expression by the prosecuting attorney of his personal belief in the defendant's guilt. Williams versus State, finding pre-trial public comment that a conviction would be the right result constituted an impermissible but not disqualifying expression of the prosecutor's opinion concerning the merits of this case, citing State versus Holman, overruled on other grounds. As guidance, Williams instructs that the trial court should take into consideration whether such remarks were part of a calculated plan evincing a design to prejudice the defendant in the minds of the jurors. Wait. So we gon' we gonna talk about something that Fani Willis said that could prejudice the jurors when Donald Trump has been rogue, prejudiced. Everything that says is an attempt to prejudice the jurors. Wait a minute. Are you kidding me, Judge Mcaffe? As guidance, Williams instructs that the trial court should take into consideration whether such remarks were part of a calculated plan evincing a design to prejudice the defendant in the mind of the jurors, or whether such remarks were utterances. Also, okay, hold on. Also notes that while a prosecutor's comments may be considered improper, they must be egregiously so to justify disqualification. This course has not located, okay, this, I think this is in regards to maybe the speech she gave at church on Martin Luther King. Was it Martin Luther King Day? I think that's what this made, because I remember those attorneys, they kept bringing up her speech at the church when she was basically calling these people racist, and why are they going after one and not the other, and da right? So I think this may be in regards to that. This court has not located nor been provided with a single additional case exploring the relevant standard for forensic misconduct, or an opinion that actually resulted in disqualification under Georgia law. Left unexplored, therefore, is how other examples of forensic misconduct can manifest, such as whether statements that stop short of commenting on the guilt of a defendant can be disqualifying, nor has it been decided if someone showing or of prejudice is required, and how a trial court should go about determining whether such prejudice exists, nor is it clear whether the analysis differs depending on the pretrial posture of the case. Unmoored from precedent, the court feels confined to the boundaries of Williams and restricts the application of the facts found here to its limited holding. The defendants have exhaustively documented every public comment made by the district attorney concerning this case through their motions and supplemental filings. Many of these have already been addressed through a pretrial challenge made on similar grounds brought by defendant Trump and Lathan. Then it gives the order that this court incorporates and adopts the sound reasoning of Judge McBurney that finds that any comments made by the district attorney prior to July 31st, 2023 did not amount to disqualifying forensic misconduct. Public comments about the need for and importance of the investigation fall far short of the type of bias, explicit or implicit, that must be found. Similarly, more recent comments describing the charges in the indictment, the procedural posture of the case, the office's conviction rates, and personal behind the scenes anecdotes are not disqualifying. This includes the district attorney's unorthodox decision to make on the record comments and authorize members of her staff to do likewise, to author's intent on publishing a book about the special grand jury's investigation during the pendency of this case. Such decisions may have ancillary prejudicial effects yet to be realized, but the comments do not rise to the level of disqualification under Williams. The same cannot so easily be said of the district attorney's prepared speech delivered before the congregation of local Atlanta church on January 14, 2024. In these public and televised comments, the district attorney complained that a Fulton County commissioner and so many others questioned her decision to hire Wade. When referring to her detractors throughout the speech, she frequently utilized the plural they. The state argues the speech was not aimed at any of the defendants in this case. Maybe so, but maybe not. Therein lies the danger of public comment by a prosecuting attorney. By including a reference to so many others on the heels of defendant Roman's motion, which instigated the entire controversy, the district attorney left that question open for the public to consider. The court finds, after considering the statement as a whole under all the circumstances surrounding its issuance, that the district attorney's speech did include defendant Roman and his counsel within its ambit, whether intentional or not. More at issue, instead of attributing the criticism to criminal, let me remind you, we've already gone through this doesn't meet the conflict of interest based on Georgia law. We've already said that based on Georgia law, the appearance of impropriety, we've already went through all of that. We already went through what his order was. I've ordered that the case can continue just to remove the appearance of impropriety. If they want to continue, then just get rid of Wade. We already done went through all of that. This is all his extra fluff. All his extra fluff. More at issue, instead of attributing the criticism to a criminal accused general aversion to being convicted and facing a prison sentence, the district attorney ascribed the effort as motivated by playing the race card. She went on to frequently refer to Wade as the black man, while her other unchallenged district attorneys were labeled one white woman and one white man. The effect of this speech was to cast racial aspersions at an indicted defendant's decision to file this pretrial motion. However, the speech did not specifically mention any defendant by name. Although not improvised, it also did not address the merits of the indicted offenses in an effort to move the trial itself to the court of public opinion. Nor did it disclose sensitive or confidential evidence yet to be revealed or admitted at trial. In addition, the case is too far removed from jury selection to establish a permanent taint of the jury pool. At best, it can divine under the sole direction of Williams. The court cannot find that this speech crossed the line to the point where the defendants have been denied the opportunity for a fundamentally fair trial, or that it requires the district attorney's disqualification. So I guess at some point during their closing arguments, they brought up this speech that she gave at the church, and she mentions the one black attorney versus two white attorneys, and they're basically saying she's tainting them as being racist because she's playing the race card or whatever. And he's saying that is not grounds for disqualification because she didn't say any names, and this didn't taint the jury pool because she didn't say any names, and she didn't specifically mention defendants and apply it towards any of that type of thing. Okay. But it was still legally improper. Got to throw a bone to the MAGA nuts. Still legally improper. Providing this type of public comment creates dangerous waters for the district attorney to wade further into. The time may well have arrived for an order preventing the state from mentioning the case in any public forum to prevent prejudicial pretrial publicity. Bitch, if they wouldn't have brought this shit about, she wouldn't have had to feel the need to defend herself out in public. They are trying this case out in the public, right? And they are discrediting this woman so horribly that she felt a need to have to come out and publicly defend herself. Where was your order? If once you agreed to this circus, where was your order to protect your district attorney? Where was your order to say nobody can talk about this case out in public? Where was your order? But this is not the motion presently before the court. The defendant's motions demanding disqualification and dismissal based on forensic misconduct are denied. So he's denying their motion to have her removed because of what they said she said out there in public that they feel taints them and the people that they're representing, the co-defendants. Other grounds are going into another section called other grounds. The defendants invoke a range of other constitutional, statutory, and county provisions in support of disqualification under Georgia various provisions of the Fulton County Code, including financial disclosure requirements and alleged payment and hiring violations pursuant to that. This statute does not place limitations on the appointment of a special assistant district attorney to work on a specific case as opposed to the county approval of a general employee. See amusement sales, While Wade's contract did not limit his work to any particular case, the testimony established as much, and the defendants have not produced any evidence demonstrating that his work ever expanded beyond this prosecution. Further, to the extent the defendants argue the circumstances of Wade's loyalty oath create independent grounds for disqualification, the court incorporates its previous order on the subject and denies the motions. See order on defendant Cheeseboro's motion to dismiss indictment for failure to comply. As for the remaining provisions and arguments, the court has not presented with any authority that such violations, even if proven, amount to an actual conflict of interest, nor that an appearance of impropriety can apply to any instance of inappropriate or wrong behavior. In each case, applying the appearance standard, the impropriety was connected in some way to an allegation of a potential and previously recognized actual conflict. In a separate motion, adopting the arguments of her co-defendants, defendant Lathan presents, this is Donald Trump's co-defendants, presents an additional theory. She asserts the right to call the district attorney as a witness at trial to examine her biases toward the defendants and demonstrate that she brought a politically motivated prosecution, accepting the sole citation raised in support. Duncan versus State, physical precedent only, allowing impeachment of the prosecutor for improper motives or bias. This requires ignorance of the opinion surrounding context. Actually reading the case and the authority upon which it relies, and not simply quoting a head note, reveals that the Court of Appeals' antiquated use of the word prosecutor referred not to the legal officer handling the criminal case on behalf of the public, but rather the main witness for the state. Defendant Latham asserts a claim accurately categorized as one of selective prosecution, and the United States Supreme Court has recognized that such claims are not a defense on the merits to any criminal charges themselves. United States versus Armstrong, da 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 da. Instead, a claim of selective prosecution must be brought in the form of a motion asking the trial court to exercise its judicial power on equal protection grounds. Lacking such a showing here, or any foundation in law or the rules of evidence, the motion is denied. Conclusion: whether this case ends in convictions, acquittals, or something in between, the result should be one that instills confidence in the process. A reasonable observer, unburdened by partisan blinders, should believe the law was impartially applied, that those accused of crimes had a fair opportunity to present their defenses, and that any verdict was based on our criminal justice system's best efforts at ascertaining the truth. Any distractions which he allowed, any distractions that detract from these goals, if remedial under the law, should be proportionately addressed. After consideration of the record established on these motions, the court finds the allegations and evidence legally insufficient to support a finding of an actual conflict of interest. However, gotta throw that bone, y'all. However, the appearance of impropriety remains and must be handled as previously outlined before the prosecution can proceed. The defendant's motions are therefore granted in part and denied in part. Judge Mcafee's ruling, everybody. Judge Mcafee's ruling. So now, I'm wondering where they will go to next, because he gave them ideas on where they can go to next. Let me find it. Let me find it. I passed it. Hold on. The odor of mendacity remains. You allowed this crap to come through. The odor of mendacity comes from Donald Trump and his cohorts. Here it is. So he gave them suggestions on where they can go. The Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, which has already thrown it out, or the Fulton County, or the voters of Fulton County, which is us. I'm not in Fulton County, but y'all get my point. Y'all get my point. Y'all could continue to attack this black woman by going through these avenues. Is basically, yes, he's a federalist judge, which which is what he's basically saying. And it's always It's always in response to appease the right. These people who are making these decisions are always admonishing or attempting to trash the left. You're talking about her behavior, her saying improper things publicly that could prejudice the jury when that's all Donald Trump has been doing. That's all that Donald Trump has been doing. But you're going to slap the hand of Fani Willis. We're going to see if a motion or if I know somebody has already sent something to ethics the Georgia State Ethics Commission because of some other issue somebody brought forth. A whistleblower of some sort. She fired a whistleblower, and we don't know all of the ins and outs of that. It's the MAGA nuts that are coming down into my comments talking about, oh, y'all are celebrating now, but she's going before the ethics commission because she fired a whistleblower. Bitch, you didn't have nothing to say when Donald Trump fired James Comey. Y'all didn't have nothing to say. That's the same exact thing. Y'all got a problem with when she do it. It's no problem when they do it, but it's a problem when she do it. Okay. Just like all of this impropriety, $3,000 worth of travel expenses that probably just went by the wayside, because I don't know, when I go out with my friends and I need to spot the bill and they come back and pay me, if the bill is $57, they might pay me $60. They may pay me $50. We ain't stressing over that extra $7 or $3. We're not stressing over that. That might be how they do in their spaces. We don't do that shit in our spaces. Hell, there's been plenty of times when I was much younger and was traveling, where I paid for my friend's travel because we had to pay by a certain day and she didn't have it. So I paid for her travel. And then later on down the line, she paid me back. Shit. She paid me back. Or when we got to where we were going, she paid the hotel fee. She paid for the hotel. Or hell, she bought dinners. And yes, black people keep money like that in our houses. Daddy Willis explained it perfectly. See, they don't understand that level of racism because they don't have to deal with that level of racism. We have to deal with it. We have to always make sure wherever we're going, we've got cash money. If we're going out on a date, we were taught, women, black women, make sure you got your own money. Make sure you got your own money. You traveling, make sure you've got money. Make sure you've got money. Not credit cards, money. They don't understand that because they don't have to deal with that level of racism. I knew exactly where she was coming from when she said she got money in her house. Shit. Somebody said I have a lockbox. She said she got her first lockbox from her daddy. I have a lockbox. One of my Lucille's is in the lockbox, and there's money in the lockbox. Come on now. But they don't understand that. They don't understand the black experience in this country. If there was a black judge sitting on that bench, he would have understood completely where Fani Willis and Fani Willis' daddy was coming from. There's money in the car. We got money stashed everywhere. Now, depending on your financial status in this country, some have more stashed than others. Come on now. And Judge, yeah, I don't know if he's with the state. I don't know if he's on the federal. If his ass shows up on my ballot, I won't be voting for him. All of this trying to taint her to be some kind of way, that just turned me completely off. You could have left it at straight legal. All of the advice that you gave for them to continue to harass and attack this woman because she is filing criminal charges against individuals who violated the law. Hey Aisha, I see you down there. LOL, Lolo 60. I'm talking about black women. I'm not talking about all women. Y'all love to turn everything into all women. I'm talking about black women. I'm a black woman talking about the black female experience, the black woman experience. Period. 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 I don't know why y'all get so upset about black women talking to black women about the black experience. Y'all always feel left out for some strange reason. I don't know why I don't know how my mouse just all of a sudden decided to only connect to my iPad. Yeah, Aisha. I don't want to talk about it no more because it's giving away too much of our secrets. Just like Chantal still fighting with racist white women because she mad, because they mad that she said her jewelry is for black women. And what type of jewelry does she sell? She sells Afrocentric jewelry. You know, jewelry with the Africa pendant, with the Black Lives Matter fist, with the Queen Nefertiti, all of these things that represent black people. They're mad that she said her jewelry is catering to the black woman. She didn't say white women can't buy her jewelry. She's just letting white women know that it's catered to black women. If you want to walk around with a black fist on your chest, by all means. If you support Africa and you want to buy a pendant of Africa, by all means. She's just letting you know. And they all upset. They take it personal when you don't center them. For real, they really take it personal. If they aren't the center of the focus, they get real upset and want to correct you. Not all women. It is like when a black man gets up on his platform and says, "Good morning, black women." They'll come around and say, "All women." Say good morning to all women. Child, I hear you, Lolo. You may support me. I'm just correcting you. I'm just correcting you. Just because you support me does not mean you can't be corrected. I'm correcting you. I'm talking about the black female experience with black women. No, I don't. I don't entertain their feelings anymore. I don't. I don't. So the other thing that's popping off, I keep wanting, and I don't know how to fix this shit with my mouse. I guess I'm gonna have to shut everything down. Let me take the batteries out for a sec. Hold on, maybe that'll correct the problem. It'll reset. I wanted to talk to y'all. I didn't know this was. I mean, I knew this stuff was happening, but I didn't put two and two together. So I heard Muscles talking about it, and I was like, "What?" I now it makes sense. Y'all know how all of these cases and challenges, these lawsuits that are going through these. Where you going? You heard me getting loud, so you had to see what. No, you're not getting in my lap. Y'all know how all of these cases that are being brought, these lawsuits that are being brought, like the Heritage Foundation, and all these other right wing racist organizations, they seem to, for some reason, go through Texas only for it to then be pushed up to the Supreme Court. Have y'all noticed that? The affirmative action case, it went through Texas and ended up at the Supreme Court. Mifepristone, it went through some court in Texas and then ended up at the Supreme Court. What's the other one? There was another one. Abortion. There's some legislation about abortion. It went through Texas and ended up at the Supreme Court. Now I knew this, but I didn't know this. It wasn't connecting. And so when Muscles did a real quick video that I came across, and I was like, what? So what these right wing organizations have been doing is that they've been bringing forth these legal challenges, and they've been steering them through this judge in Texas, knowing that eventually it will end up at the Supreme Court. They've been purposely doing this. They have certain judges in their pockets, certain right wing judges in their pockets, and they will file their legal challenges in these particular courtrooms, knowing that it will then get pushed up to the Supreme Court. I did not know this. And now what's happening is John Roberts is putting a stop. I guess he saw what was going on, and he is attempting to put a stop to it. I wanted to read this article to y'all. This is what the article looks like. Y'all if y'all want to share it on y'all platforms to educate the people, because I ain't seen this on MSNBC. That's really the only one that I watch. This is the article. It's done through Slate. How is it legal, JC? How is anything that these nut jobs are doing legal? Hey, sweetie pie. How is it? It is. They're basically shopping around for a judge that will take on the challenge, and then it'll get shot up to the Supreme Court, where they know they've got the Supreme Court in their pocket, and then it becomes national law, right? National law. And so that's how they are pushing through these challenges that are now affecting all of us nationwide. They're pushing it through these handpicked judges that are on their side. These LGBTQ legal challenges, these abortion challenges, these birth control challenges. I want to read this. Hold on, I showed y'all where you can get it. Okay. So, for more than a decade, conservative plaintiffs have been gaming the judiciary by filing lawsuits before a hard right judge who's guaranteed to rule in their favor. This is how they've been getting this shit done. Worse, a handful of Republican appointed judges have made a habit of issuing sweeping decisions that apply nationwide, hobbling the federal government, short circuiting the democratic process, and transferring inconceivable amounts of power into the hands of a few elected jurists. The Judicial Conference of the United States, which makes policy for the federal courts, finally struck a blow against this cynical gamesmanship on Tuesday, announcing a new rule to restore the random assignment of cases and close the loophole that lets plaintiffs handpick their judges. So these evildoers have been going to these judges that they know will rule in their favor and then shoot it up to the Supreme Court where it will then become national law. On the slate, okay, so then they talk about how this is going to be talked about on their hold on, let me see if I can get into it. No, I can't. They're going to talk about it in more detail on their podcast. But this is what they have been doing. And in response to that, these evildoers said, F that commission. F that commission. We ain't paying attention to that commission. We're going to continue to do what it is that we've been doing. Judge Roberts said we gonna implement a process where judges will be randomly picked to will be randomly picked to choose these cases. I'm telling them about this case that you talked about, and I was like, oh, I need to let me see if I can get to the podcast episode. When I click that link, nothing happens. It brings up this blank page. Oh wait, this is something they want me to. Hold on, it came up on the. Okay, let me think for a minute. Something came up. Let me click it again.
Playing from Beautiful's MacBook Pro.
Child, they always want you to pay for something. I'm not paying for it. We get the gist of it. These evildoers, Stephen Miller, not the Federalist, the Heritage Foundation, all these other, these people who've been bringing these lawsuits. It's been flowing through their handpicked judges, and then it ends up at the Supreme Court, and then what ends up happening, the Supreme Court will rule in their favor, and then it becomes national law. That's how they've been pushing forward this shit. And Judge Roberts said, no more. We're going to implement this system where these cases will go to randomly picked judges. But the MAGA nuts are, what you mean let you in? Hold on. You didn't send a thing? Muscle, send a thing. It's not it doesn't show that you sent a request. Hold on. I'm in this other screen. Maybe it'll show. Oh, here you are.
Good morning, gorgeous creature.
Hey, what? Why are you so small? How do I
Because
make you
you're in a,
bigger?
it's like you're in a multi thing instead of a duet. It's a multi request, so you could have like 10 people in here. That's why. It's not a dual. I know it's not a dual screen. So this is what happened with that judge. What they were doing. First of all, Mitch McConnell hates it, so that means it's good for America. If Mitch McConnell hates it, it's good for America. So what they were doing is the judge in Texas in Amarillo is the only federal judge. He's a standalone judge.
Right.
So and
His
also in
name starts with an M.
Girl, I can't pronounce that. I pronounce
Yeah,
it. But I
starts with
can't
an M.
pronounce that. So they were going to him, and if you guys don't know, Texas has banned PrEP, meaning they no longer cover PrEP. The Affordable Care Act, the
I
reason
remember
why
that.
the Affordable Care Act, why it doesn't cover preventative measures anymore, is because of that judge in Texas. Mifepristone is because of that judge in
No
Texas.
whiskey.
And so what happened is the American
No, stop.
no,
No.
okay.
He's demanding attention. He's a bully. Go ahead.
So that judge in Texas would implement a federal national ban. He would put an injunction on all of it. So what Judge Roberts has done is because of where he sits in his appellate court, he's now forcing it so they can no longer do that. So if you're going to take a lawsuit that could possibly impose a national restriction on something, it's no longer your case. You have to give it over to the spinner and it will be randomly assigned. And they're really upset about it because there were cases going through gay marriage. There's a lawsuit in front of that judge right now. Bubbles!
So I read, I typically go down into the comments to see what people are saying. And so I read that
Bubbles!
it doesn't go back. It's only for cases that are filed in the future.
Right. Yeah. It does. Yeah. It's not retroactive.
Right.
So anyone going forward now, which sucks because there's currently a gay marriage lawsuit in his court right now, which could actually do a national injunction. Like people don't there's so many cases in front of that judge right now that will affect the entire country. Like it's actually, and part of that has to do with biracial marriage too. That lawsuit, they want to try and make it so that people, you know what I mean, don't have to perform biracial marriages. It's part of that. So this is actually really, really big, and it's not talked about. Like Mitch McConnell is saying he's trying to fight it. What are you gonna fight? That's the fucking Chief Justice.
Okay. So also what I saw was that they were like they're not going to follow what he puts into place, and I'm like, well, how are you going to do that?
Well, then that's an illegitimate lawsuit. That meaning that the other states will not have to recognize that national ban because it didn't go through the spinner.
Headphones alone.
Right. It won't go through the spinner, and they can try and take it up to the Supreme Court, but Chief Justice has the ability to say, no, we're not taking the case.
But would they do that?
Would they do it? Absolutely, they'll do it. They keep pushing you got to think the ban that Trump did, the original Muslim ban, that was a precursor. Anything that Republicans are doing right now and losing are precursors. They're setting precedent. A lot of people don't get it. That's why when I hear these uncommitted voters and things like that, like, you don't understand all these lawsuits that Republicans do. They set precedent. They go to different courts and they get it at least on paper, and then they figure out a way around it.
Right.
And then they weaponize the Constitution and they set precedent. They look for judges to set the groundwork, and then bam, they take it to the Supreme Court. So all of this stuff has been going on for 50, 60 years of just building up and building precedent. I gotta go get Bubbles. She just ran off. All right. Bye.
Thank you. Bye. All right, y'all. I guess Whiskey's gotta go potty because he's all over me. Okay. I want to thank y'all for hanging out with me, but yeah, that's interesting. These mofos, y'all, we have to vote blue. That means at the executive level, that means at the legislative level. The legislative level is is Congress, 535, a whole bunch of seats are up for re-election in November. So pay attention, a whole bunch of House representatives and Senate seats are up for re-election. We have to, I know a lot of us aren't happy with the Democrats. I know a lot of us are not happy with the Democrats on different levels. I'm one of them. But the one thing the Democrats aren't trying to do is destroy democracy. That's the one thing they are not trying to do. They are not trying to destroy democracy. We've got to get these evildoers out of office. We have to get them out of office. Child. We have to get them out of office. They got to go. They are not working in the best interests of all Americans. They are not. I'm so unhappy with Democrats. Y'all know I don't care about, I really don't care about this TikTok ban. But I'm upset that Democrats signed on for this TikTok ban. I'm upset about that shit. I believe the Democrats and the Republicans who signed on to this TikTok ban, I believe if we look deep enough, we'll find that they've all taken money from AIPAC, because I believe this time around, AIPAC is one of the biggest contributors for this TikTok ban. Everybody's talking about Facebook. Yeah, Facebook will benefit from it, but I believe the spearhead for this TikTok ban is AIPAC, because I remember not too long ago that bald-head man was on MSNBC talking about we need to get rid of TikTok because they aren't being the Jewish elite are not being put in the best of light. Those who work for Israel over in this country, y'all know, I believe AIPAC should have to register as a foreign agent, right? Because they're not stomping for all American rights. No, they're stomping. Oh, I know why I get it now. They're stomping for Jewish rights, for Israel. They're not stomping for Americans. So I will never forget him being on MSNBC talking about TikTok needs to go because TikTok is spreading misinformation. No, he was upset that Palestinians has a voice on TikTok. Palestinians can show us what's really happening over in Palestine, over in Gaza. And that was shaping the opinions and the minds of other people. We were able to see what you were saying on MSNBC, what you were telling us, and then we were able to see what was really Jonathan Goldblatt. Thank you very much. And then we were able to see that you motherfuckers was lying. You motherfuckers was lying to us, because we can literally see what's going on. We can really see it. So I believe they are the main reasons. They're mixed up in it as to why now TikTok is being banned. And that's why you see Democrats and Republicans signing on to this, because Democrats and Republicans are in the pockets of AIPAC. AIPAC owns Democrats and Republicans. That's my belief. That's my belief. So I don't even know how I got on this, child. The ban is about voter suppression. I don't think 100% that's what it's about. Am I being suppressed? Absolutely. Absolutely. My voice is being suppressed. Absolutely. But at the same time, I'm still reaching thousands of people. I'm not done with MSNBC. Hey, Harmony. I'm not done with MSNBC. As long as they have Joy Reid, Rachel Maddow, who's The Weeknd, Michael Steele, and Simone Sanders. Who's the other one? Ari Melber. Who's the other one that I watch? Y'all know I watch Morning Joe. I have a love-hate relationship with Morning Joe. And if Morning Joe didn't have people on there like Michael Steele, like Reverend Al, who's the other lady? That other lady, she's got this beautiful curly hair. I don't know her name. And there's a couple more people, couple more black women that they bring in from time to time. If they didn't have them to set the record straight, I probably couldn't stand watching Morning Joe. But yeah, we were talking about democracy and the vote. 500, 400, 500 representatives are up. Elections have consequences. We've got to get the right people in and the wrong people out. The wrong people out. Y'all know I'm not with the vote blue no matter who. I'm not with that. No, sir. So do your research. Do your research. Okay? Do your research. Make sure you're right. You're voting for the right blue. The right blue. Okay? Okay, I gotta go because if you could see this death stare, if you can see this death stare, baby, I will see y'all later. I'll be out there on social media today, doing what I do. I don't think anything's popping off. I think we were all waiting for Judge Mcaffe, and I just went through his entire order. And now we know what's up with Judge Mcaffe. If he's on my ballot, I wouldn't vote for him. I think he's a Republican anyway. All right. All right. I love y'all. Y'all have a fantastic Saturday. I'll see y'all later.